So when shall we start, sir?
Shall we start in couple of minutes, like 2-3 minutes? Just wait for like another 2-3 minutes, then we start.
Okay, sir.
Yeah. Participants can put some welcome message or uh, hi message in chat box so that you can see the participant name and department, or from outside college you can put your college name as well. Kindly type in, yeah. No, we can start. I'll ask Mr. Ibra to join.
Okay, sir.
Ibra, sir, are you there? I think he is not available, right? When he's not in. Ma'am, Sindhu
Yes,
ma'am,
sir.
can you restrict the admission now? Can you restrict the admission? Can you ask when don't admit everyone because we have
Oh,
only five and the
okay,
speaker
okay.
has to join.
Okay, okay, sir.
Restrict the admission now.
Hello.
Yeah, yeah.
You can hear me,
Okay,
right?
okay, okay. I just calling you.
Okay, sure, sure.
Shall we start, sir?
Sure, sure. Give me a
Shall,
second.
Yeah,
shall I start, sir?
yeah. We can start.
Okay. So pleasant morning to all. So this is Sindhu, IIC convener from C. Abdul Hakim College of Engineering and Technology. It's my immense pleasure to welcome you all on behalf of the management, our correspondent, Dr. V.M. Abdul Latif Sahib, our chairman, Dr. A. Ziauddin Ahmad Sahib, and our principal, Dr. J. Bhaskaran, and our IIC president, Dr. C. Muhammad Yusuf, and our IIC coordinators and my colleagues to our Ministry of Education's Institution Innovation Council sponsored Impact Lecture Series Session 2 in the theme of intellectual property rights. I delighted to welcome our eminent speakers, Mr. Muhammad Ibrahim Noor, Managing Director, New Vector Solutions Private Limited, Mr. Ashok Doplapudi, Manager, Intellectual Property Mahendra and Mahendra, for today's session. I extend my heartily welcome to all our participants from various institutions for this wonderful session. I ensure that this lecture session will be thoughtful. Once again, I welcome you all. So now I invite Mr. C. Muhammad Hashim, IIC Ambassador, Intellectual Property Rights, IIC Catchet, to deliver a keynote address on IPR. Over to you, sir.
Thank you, Sindhu ma'am. It's a pleasure to being part of this Impact Lecture series organized by MHRD and Ministry of Education. It gives me immense pleasure to be part of this series, where in last series we had about startup, and this is the second series where we are discussing about IPR, and it would be a great, very fruitful session because of our very rich and experienced guest, Muhammad Ibrahim Noor, who has very rich experience in IPR. So before we proceed to actual session by the guest, we'll give an outline what is happening in our college regarding IPR. We have an IPR cell in cassette. For those who are new final year students, we are making them aware that the IPR cell takes care of their requirement to present their, convert their project before going into project, convert it into an patent. Okay. Before that, let's discuss what's necessary for going into patent. What exactly is patent? This session is a part of second session. First session we had about startups, and second immediately we have it about IPR. How does startup and IPR together is related? I will give an example. For example, if you need to start a build a startup, the first thing that is necessary is an idea. Okay, so once you convert an idea into a minimal viable product, you have a prototype to before launch, and before launching that prototype or before launching that product into the market, it is necessary that you study the market and make sure the idea, the product is protected by applying a patent. Okay, so that's where the IPR is a part of a startup ecosystem. And when you also, when you're going to launch a startup, it is also necessary that you have a name registered, and that name is also comes into the IPR. The name that you assign for the startup, you need to probably make sure that is already trademark. You apply for a trademark of that name, and make sure that it is not been used by some other companies, and in future you should not have a legal issue with that name. So before we launch anything, either in startups, and we go for protection of our idea, and the legal government body gives us the right to protect our idea, the product, and also our entities like the logos, names, everything. So in our college, we guide the final year students before going to their final year project. They come up with their ideas, and we go and check the novelty, innovation, and their application, and make sure that it can be patented, or they need to tune up their idea to something more novel. Okay, so that's the process we undertake in our college to the students. And also before publication, we also recommend the students to go for if the idea is really novel and it can be patentable, we do a patent search and make sure that it's not already existing idea. So, and then we recommend to apply for a patent. Okay, so I expect the students take care of the session thoroughly and have a good overview of the patent and the whole intellectual property rights, all design patent, design applications, patents, and trademarks and copyright. With our chief guest, I hope he will enlighten in detail everything. And thank you for Muhammad Ibrahim for accepting to uh, deliver your experience and knowledge to our students. So we expect our students will take a full advantage of your speech today,
Sure.
and hopefully we will collaborate even in future, and maybe you can even consult us on proceeding to file the patent in upcoming days.
Sure, sure.
Thank you. Over to you, Sindhu.
Thank
Thank
you.
you. Thank you, sir. Now I invite Dr. C. Muhammad Yusuf, IIC President, Catchet, to address the gathering. Over to you, sir.
Good morning to all. First of all, I'd like to thank our speaker, Mr. Ibrar, for accepting our invitation in quite short time. So he accepted our invitation without a second thought. So we are very much grateful for you, sir.
You're welcome. Thank you so much, sir.
I'd like to thank our management for providing us an opportunity to organize this event, and especially our the MOE, Ministry of Education, Institution Innovation Council, for sponsoring this event. So we have a speaker from Neo Victor Solution, Mr. Muhammad Ibrahim. He is the founder and director of Neo Victor Solution. So to look onto the profile of the speaker, Mr. Ibrar was a lead patent engineer with Ford Company, Ford Global Technology, based in India. So where he managed all kinds of projects related to patent. So during his tenure at Ford Global Technology, so he was able to travel to various facilities of Ford Motor Company and got trained on various aspects of patent and inventions by patent attorneys and inventors from USA, UK, and Germany. Previously, before that, Mr. Ibrar started his career as an academician and as a teaching graduate engineers. He taught at various engineering colleges, including the Central University, Jamia Millia Islamia, New Delhi. Later, he moved to eValueServe, a patent service company, as a patent analyst. And there he received intensive training on various aspects of patent. Within a short span of time at eValueServe, he became quite a favorite of his manager, especially when it came to handling crucial or technically complex projects. This is because he always delivered to clients' delight. So later, finally, he worked with Ford Motor Company for more than 7 years. So in total, Mr. Ibrar has got a total of 10 plus years of working experience in field of patent. After then, he started his own industry, New Victors, so where they work for patent research, managements, etc. Okay, so I hope, like, based on his experience and the work that he contributed in the field of patent, as our participants, all our students, basically here we have the students from different departments, all from our college. So we'll make the full opportunity of this talk. I hope the participants will make this session fully useful, and we'll have like a joyful moment for the next 2 hours, 3 hours. So we have already started. The session was started with a startup, as Mr. Hashim mentioned. It is just a follow-up of the previous session, so which held on 4th October. I hope that those who have attended 4th October session would like to easily combine this session together well. Even for those who have not attended, they will know about what the patent is and how they can go for patent their product they have developed. Even the project, the final year project they are doing, they will come to know how they can patent their final year projects. Okay, how they can commercialize it and how they can protect the rights for their developed project. Thank you to everyone for being part of this event today. I'd like to conclude my talk, and I'd like Mr. Ibrar Noor to take over the session now. Thank you very much.
Thank you so much, Mohammed Yusuf and Mohammed Hasim and Sindhu, for having me over here.
Thank you.
You're welcome. And yes, allow me to share my screen.
Yeah.
I hope you are able to see my screen.
Yeah.
Okay, good, mashallah. So, we are going to talk about we are going to introduce in this session the intellectual property rights. So let's start with the types of IPR. That is intellectual property rights. So we have copyrights, we have trademarks, we have patent, we have industrial design, we have trade secrets, we have geographical indications. And how this starts, IP activities, that is intellectual property rights creation activities. I would rather say that once you create it, in fact you innovate it, you create it, then you apply protection to it, and then you start commercializing it. And after that, there's always a people freeloaders, they call it. They would try to use it for free. They would try to copy it. Then you enforce your protection against them. And IPR rights is in fact, it's a property. It's very much like real estate property, in fact. So they call it houses, cars, lands, what and what not. It's a tangible property. You can see it, you can touch it. In case of IP rights, you can't see it or you can't touch it at least. But then that is they call it intangible property. It's very much when we talk about real estate rights, you have a plot A, plot B, and plot C owned by different people. In case of IP rights, very much plot A is invention A is owned by one person, invention C is owned by another person, invention B may be owned by you. And if this is the case, then the one who is owning the invention A cannot cross the boundary of the invention B. Similarly, invention C owned by somebody else can't cross the boundary of invention B. If they do so, they can be sued in the court of law. Very much like real estate property, that if they try to get into your boundary, you can stop them, or you can very much take the help of law enforcement agencies. Now the question is, why IP protection is given by the government of India, or for that matter any government from any territory. So the reason is in case of protection, when they get the protection, they would like to invest into the new products. They would like to invest into research and development. They will invest in marketing and advertisement, and they will do all these things as long as there is a protection. If there is no protection, then all these three investments will go into waste, because you do all the investment and then somebody else comes and they make use of these investment on the new product. That is you put a manufacturing unit, you spend millions, you spend another millions into research and development, maybe less than some millions into marketing and advertisement, and then somebody else will try to use that, all these three investments, and they will start selling the same product. And since there's a protection, nobody can use that for free. So you will also have like loyal followers. For example, in present scenario, you have that iPhone. It's selling very costly, but nobody is allowed to copy that iPhone. So everyone who is buying the iPhone, they are like your loyal followers. In fact, if somebody starts copying it, their quality will be low, and they will they will cause the loss to reputation of the iPhone, and people will stop buying that iPhone. So they will, I mean, the company iPhone will, I mean, Apple will lose millions of dollars because people will stop buying because of the quality. Because once they copy, there is a question of quality as well. I'll give you an example of this windshield wiper. There's a movie on that actually, Flash of Genius case they call it. So an individual inventor, he invented that invention, that is windshield wiper, and then Ford used it for free without taking any license from that individual inventor. Ford was a big firm then. I'm talking about the case from a few decades back. And since Ford used it, so few more car manufacturers, they use the same windshield wiper. Once again, they did not take any license from the inventor. Ultimately, the case went to the court, and Ford had to possibly give $20 million for the damage to the inventor. And so was the case with other manufacturers. They too had to pay that damage to the inventor. So this is how, if somebody tries to use it for free, they will have to pay. Then IP as a property, it can be sold, it can be bought. It can be sold, it can be bought, it can be leased as well, it can be rented. Similarly, it can be passed under a will, like somebody can make a will that once I die, this property will be owned by somebody else. And they can name the people. Similarly, it can be assigned in their life as well to somebody else, especially in the present scenario. Mostly the employees would be the inventor, but it is the IP rights are assigned to the company. In case of Ford, for example, the employees would be the inventor, but they won't be the owner. By default, the rights will go to the company. That's the contract they sign with the company. Then there are some international conventions for IP. One of them is Paris Convention, and there is PCT, that is called Patent Cooperation Treaty 2004. And when we talk about the Paris Convention, I mean, they protect trademark, they protect patent, and it is governed by the domestic legislation as well. Similarly, for Patent Cooperation Treaty, it makes it easier to make patent application. Then you can designate the country in which you want to file the patent. And similarly, from international phase to you can come to the national phase. I'll try to explain these three things. In fact, when you file a patent, so for it, I'll give you the example of India, that if we go by the Paris Convention, if we go by the Paris Convention, we can, within 12 months, we can file to the member of the Paris Convention countries. If we go by the PCT, then we have got more than 30 months in most of the cases that we can file a patent application with the PCT, and we will have 30 months to decide in which country we would like to file, in which country we would not like to file. And that is called designated country. So you can designate the countries while you are filing the PCT application. That is called international application. And there you can choose in which countries you would like to file the patent. You are still not filing the patent in those countries. Just by one application, you can decide in these countries I would be filing the patent application. Later, after 30 months or within 30 months, you can decide if you want to, for example, if you are a resident of India, you can decide to file in US, UK, France, Germany, what and what not. And you will have 30 months to decide. So within 30 months, you can decide, on the 29th month, you can decide to file in the US or not, UK or not. That way you can save lots of amount of that filing. So you will have got 30 months to decide. Most of the time what happens, you have an idea, and that is what you file the patent for, and you still do not have the product with you. In that 30 months, you can work on that product, and you will get to know the viability. You can also talk to some of the investors in that meantime, and you may get some investment. And if you have that investment, you can file patents in many other countries. If you don't get the investment, that also gives an indication your product is missing something. It may not be a viable product. It may not be as much of use to the public. Therefore, people are not ready to invest. And if that is the case, you will not file in those countries. And these are the basic principles of international convention, laying down the minimum requirement for the national legislation. So if there's a law in India, there's a law in other countries as well. So there are minimum requirements that has to be there in that law. So we have got patent law in India, Patent Act 1970 in India, so that it will have some basic minimum requirement that has to be there in that law. Similarly, when we talk about the convention, then each member shall accord to the nationals of other members treatment no less favorable than it accord to its own national. That is being fair with the nationals of the member countries. Now, this is for this is to introduce what is copyright. So copyright is it's a protection given for the this is the protection given for the artistic work. It could be a book, it could be a song, it could be movies and other things. And you will have the commercial rights on those, whatever you have created. This copyright, it doesn't require you to, it doesn't mandate that you must file protection to the government of India. Even if you don't file, if you have created, then that is your right, and you can stop other people from copying it. And you may you may give some license, so you may allow people to use the song. In exchange, they will pay you something. So you are the owner. You decide. That is called commercial rights actually. Similarly, you have got protection of trademarks. So once again, if trademarks, you understand Ford, you have got the logo of Ford, you have got logo of Toyota, you have got logo of Tata. These are all trademarks. Similarly, when we talk about Tata, I can give you this example actually. When you talk about the Tata and you use the Tata salt, now Tata doesn't manufacture that salt. In fact, somebody else is manufacturing. They're using that name. So Tata has given them that right to use, and they also keep on checking now and then the quality of the salt that the manufacturer is making. So they are using the Tata name, and that is how they are able to sell the Tata salt. So it is Tata who owns that trademark. And it isn't required to be registered as well. Once again, if you are using that name for long, then you own that name. In fact, in the court of law, that would be suffice that you have been using this name for maybe 10 years, 20 years, and that would be suffice an argument to tell that you own that name. You don't need to register with the government of India. This is different from the patent, in fact. This is almost similar like with the copyright as well. The copyright doesn't require to be patent, required to be registered with the government of India. If you may register, but then it's not mandatory actually. Similarly, there is another IP right that is called Geographical Indications. They also call it GI short form. So this is regarding there are some territory within a country, or maybe the country itself, from where some product is quite famous, or the quality of product is quite special. So you are not allowed to use that name. And the example is the product has to come from a particular geographical territory, and then once again the name linked to a particular geographical nature of the territory. And these are some of the examples, like Swiss chocolate, basmati rice. Basmati rice comes from some particular territory of India. Similarly, Kolhapuri chappal, it comes from Maharashtra. Similarly, Banarsi sari, it comes from the Banaras. So somebody sitting in Bihar, for example, or somebody sitting from in South cannot sell Banarsi sari if they are manufacturing that sari in some part of the South India, or some part of Tamil Nadu, some part of you may say Karnataka, whatnot. When you say Banarsi sari, it has to be manufactured in Banaras only. Similarly, when you say Kolhapuri chappal, it has to be manufactured in Kolhapuri only. Similarly, when we talk about basmati rice, it has to be from possibly it is from Punjab. In fact, it has to be from that territory only. You cannot have some rice from Bihar or some rice from UP or call it basmati rice. You may call it any name, but you cannot sell it with the name basmati rice. Then we have another IP rights that's called trade secrets. And one of the example of that is Coca-Cola. Nobody knows the actual formula that they use in making the Coca-Cola. They have kept it secret. And that is called trade secret. Now, question is, why trade secret? There are two reasons. One is it has got a very long life. In case of like patents, copyrights, trade, I don't know, patents, copyrights, and other IP rights, they have got limited life. When it comes to trade secrets, I mean, their life is unlimited, in fact. And there's another reason, and that is like if you have got some invention, and that you cannot detect in your competitors' device, car, or maybe the manufacturing plant, because in order to stop somebody from using your technology or using your invention, you must be able to detect that they are indeed using your invention. And for that, you should be able to detect if that invention is indeed existing in their product. In case your invention is not of that sort, then there's no point filing the patent, because if you file a patent, people will know what the invention is, they will use in their product, and you will not be able to detect what they are using. For example, there's some algorithm that is being used in some chip, and you will not be able to know what algorithm they are using that chip. There's an input, there's an output, but what is going on inside, if you are not able to detect, then you cannot sue that manufacturer. You cannot sue that for making that product.
Hello, sir.
Go ahead. In that case, it is better to keep it trade secret. So that is how they keep it trade secret, in fact. Then we have got industrial designs. We call it like design patent. So this is like, if you have any design, especially when it comes to like ornaments, or you have a car that has a design, it has got many parts that can be designed, which looks aesthetic to your eyes. Then this can be patented as a design patent. So like ornaments, it looks good to your eyes. You have some design on that, and that design, if it is new, that can be patented. And this has got nothing to do with the technology. The technical aspect of it, actually. It's just the way it looks. Then finally, we come to the patent, actually. So why patent rights are granted to the inventor? The reason is, I can give you the example of Mummin is just an example. So they have this formula, they knew some chemical which they applied on the, you understand, you guys know that there is something called mummy in Egypt. They found it here and there, and the body is intact, that has been kept for like thousands of years, and still they dug that up from the grave, and they're able to see the body. It is still intact. You can still see their hairs, teeth, and it all. And they had some chemicals that we still could not find what was the chemical. They had some chemicals that they knew that chemical, but they did not pass it on to their people. Actually, they didn't disclose it to other people, and somehow that information got lost. In case of patent, they can disclose that information. In exchange, the government will give them the exclusive right. The government will give them the exclusive right to the inventor for 20 years. For 20 years, they have the exclusive right. Nobody can use that technology, and whoever wants to use that technology, they will have to take the license from the inventor, and in exchange, they will pay their inventor. So this is how protection of patent comes into existence. And you can apply for a patent for a product or a process, and that patent has to be, there are at least 3 criteria. For your invention has to be new. Another is there has to be inventive step, and third is it should be industrially applicable. So you should not invent something. When it comes to industrially applicable, you should not invent something that is of no use. In fact, they say they give the example of time machine or similar things. In fact, and that in whatever you have invented, that has to be new. When we say new, then that has not been disclosed anywhere in the publication, or it is in use anywhere in the world. And even if it is new, that is not suffice. There should be inventive step. In fact, they define the inventive step in this way: either it should decrease the cost, or it should increase the efficiency. So if it is solving either of these 2 problems, then that is we call it, there is an inventive step. Then there's another criteria that is like, you should be the first to invent. In fact, if I won't use the word first to invent, because there's something called first to file, first to invent. This concept is there, and in the whole world, it has to be first to file. If you are the one who has filed the first, you get the patent for that. In America, it was first to invent. So if you have invented it first, you get the patent. And I mean, that story is gone now. In America also, it is first to file, but earlier it used to be first to invent. For that, they would maintain the diary in their research lab. So if they are working on some invention, so every day they would put something in the diary, they would get it signed, they would put the date, they would get it signed by their managers, so that they can show that record if somebody else files before them, and however they were not the first to invent. So, but then that doesn't exist anymore. It is all about first to file. So even if like you started it today and somebody started maybe a year before, you are the first to file. You are the one who has filed the first, you get the patent for that. That date is important in fact, or when do you file. So what is the role of a patent in fact? So one is like, you innovate. Another is you should be able to see the future. Example of some of the examples like Kodak, Polaroid, and Nokia, they could not see the future. They just kept on working on the same product again and again. So Nokia is out of market. It's nobody. I mean, it's simply like lost the market of Android phone. It went out of the market for quite some time. Ultimately, it got acquired by Microsoft. Kodak also is not in the market. Polaroid is not in the market because they could not see the future. So when it comes to patent, you should be able to see the future. What can come in the future, and you file patent for that, and in future you come with that product as well. And then you have the protection for that. Government gives you the incentive to promote this innovation in fact. Then finally you have an invention. How do you file it? So there are three different ways you can file a patent for that. One is the national route. So in India, you can file with the Government of India Patent Office if you have an invention. Now, if you want to go to the file to the other part of the world, same invention, there's a criteria that you must file the patent in India first, option 1, or you must take the permission from the Government of India to file it outside without filing in India. In either case, you must disclose it with the Government of India. And you have got, from that day onwards, you have got 12 months to file if we go by the Paris route in other countries who are the member of Paris Convention. There's another route that you file the PCT and you come to and then you decide which countries you have indeed planned to file the patent. So for example, you file one application in the PCT, and then you mark that you are planning to file in US, UK, Germany, China, India, what and what not. And then you have got 30 months to decide that which countries you really want to go, because every time you file a patent in every country, it is going to cost you. So you have got 30 months to decide the product that you are going to launch, which country, this product would be indeed selling, which is the beneficial, which has got a bigger market. And then based on that, you decide. So even if you have designated US, UK, and China and Germany, you may still ignore maybe China, maybe Germany. You may file only in US and UK. This way you can save your amount as well. And you get this 30 months to decide as well. So you get ample time. Then there's something called IP infringement. In fact, I'm trying to introduce some of the terms that you hear. You will hear it over here. So next time you hear, you won't be surprised what is this term is all about. And you may also spend some time, go to Google, you may look for these terms in fact. So there's something called IP infringement. So you have a patent. Now that patent, since that patent can be copied by some people, so that is called infringement. So there are two types of infringement. One is like somebody who is manufacturing the product based on your patent. Another is he or she is not manufacturing, but he or she is selling, or maybe that entity company is selling that product or distributing for sale. So for example, like in India, you have a patent and there is no manufacturing in India for that, for that product based on that patent, but they are getting the same product from China. So they're importing and then they are selling. That they are also the infringer. You can stop them also from selling that product if they have got that product from abroad and they are selling in India. They are not allowed to sell that product because you have a patent for that in India. So they are not allowed. They are not allowed to manufacture. They are also not allowed to sell. Even if they have not manufactured, they have got some product from somewhere else. They are not allowed to sell that product as well. And you will be surprised to know that this job, like there are enough job for this kind of. I mean, people try to find out whether the product that they are trying to buy from China or other part of the world, if it is infringing on the rights of some patents. So you get like lots of freelancing work from US on a product that they are trying to procure from China to sell in US, and they are trying to find out if they are infringing on the rights of some patents, I mean US patents. So that, I mean, this service is going on, this work is going on. There's a very interesting statement by one of the IP attorney. They say like, your patent is worth nothing if it is not being infringed upon. Now, there are two meanings to this statement. One is, you have a patent and somebody is trying to make some product around that, and they are not able to make that product without infringing on your patent. In that case, they will come to you, they will try to take the license from you. You make money out of it. So your patent becomes worth something. There's another option that somebody is already manufacturing some product and they have infringed upon your patent. In that case, you can go to them that since you are making a product which is infringing on my patent, you will have to take a license, or you will have to pay the damage that you have caused by manufacturing the product for which I am having the right. In this, I mean, if these two cases are not happening, then your patent is worth nothing. You do not make any money. I would also like to give you a data that, I mean, possibly a fourth, if I remember the number, that the only 2% of the patent of the Ford makes some money. 98% of the patent makes no money. And now, when I'm saying 2%, that number may be 3, maybe 4. So maybe the 4% of the patent is making money. 96% of the patent is making no money. So this is how it happens, that if that patent is not being infringed upon, it will make no money. There are a few more aspects to this infringement, in fact. I mean, when it comes to like filing a patent, or we'll come to this actually, infringement again, maybe in a few more slides later. Oh, there's a mistake over here. Then there's something called commercialization. In that case, like we call it like assignment. You can sell your patent to somebody, and if you are selling it, we call it in the IP terms, it is assignment. So you can assign your right to somebody else. In exchange, you get some money. It's very much like you are selling your real estate to somebody else. You get the money, and that land is owned by somebody else now. There's another option that is like licensing. So there's called exclusive license, non-exclusive license. In case of exclusive, I mean, he has got the right to manufacture the product, and you cannot give the same right to anybody else, including you yourself has got no more rights to manufacture that product. That is called exclusive right. Another is non-exclusive. Somebody is having the rights of manufacturing the product based on your patent, but the same rights you can give it to many other people, and you can get the royalty amount from them. This is how like exclusive rights, exclusive licensing, and non-exclusive licensing works. Then we come to the, how the invention happened. This is a topic that possibly not many people have talked about. Many times we talk about the Einstein and we say like he was a genius, and many other terms. Similarly, we talk about any other inventor. We talk about Bell, or for that matter, any other inventor. We talk about like, the founder of the Steve Jobs, and we say like he was a genius. And fine, we may call him a genius, but there's something else beyond that as well, that what works with the invention. So we'll talk about beyond that on that aspect of the invention. And this may remove some of the fears that you have in your mind that you need to be extra intelligent in order to be an inventor. That is not the case. So how do they make so many inventions? How they are able to make Some people are able to make lots of inventions, some people are not able to make those inventions. We'll talk about that maybe in the following slides. So there's a concept called like the multiples. And the multiples is like, one of the example is of that multiples is like there was 23 individual inventors for electric bulb, including Thomas Edison. What we know about, in fact, is that Thomas Edison is the one who invented the bulb. But truth is there were 23 more inventors who invented the bulb. And why it happened, we'll talk about in the following slides. But the truth is, like, Thomas Edison was not the only one, and therefore the concept of like somebody is genius, somebody is special, unique, that almost goes away. Of course, he was much better than many other inventors of that time. There's no doubt about that. But he was not the only one. He was not the unique. Similarly, like, you talk about like, phone, telephone. There were like, two inventors. There were like, two inventors. Give me a second, actually. I'm sorry. You're able to see my screen, right? Brother Yusuf.
Yes.
Okay. I thought you were messaging in between.
Yeah.
Okay.
It's okay.
So this multiples, when you talk about that, you talk about an invention, you will find more than one inventor for the same invention. What we have read in the book, there was an inventor. Edison was the one who invented the bulb. There was like, Alexander Bell, he was the one who invented the telephone. But the truth is not. There are many more inventors. The timing may have been different. Somebody invented first, somebody invented the second. We'll talk about why this is happening. So there's a very smart, there's a very like, very good statement by Gladwell. He says that genius is not the unique source of insight; it's merely an efficient source of insight. So he's not the only one. I mean, when we talk about genius, he's not the unique one. He has just spent some more time. He has got just some more knowledge than maybe the rest of the people. So that knowledge existed, and he has spent more time on that. He was able to like, extract more knowledge in less time, and then some people, they took more time. So in case of like, when you talk about the bulb 23 inventors, there are people, they came later than him, maybe a year later, maybe 2 years later, maybe 3 years later. And you may also wonder, like, they might have copied each other, but then we are talking about the time when there was no internet. So people like, somebody who lived in the US or somebody who lived in India, they invented the bulb within a year. So no, they were not connected to each other. They simply did not know each other. They did not know the journals in which one published their invention. Still, they were able to come out with the same invention. So they did not copy, in fact. Now we can say, like, since we are living in a Google age, so you may say, like, somebody invents today, tomorrow somebody else will be knowing what the invention is. And they may say, oh, I invented the same thing. That is not how it happens then. So there are two examples I have taken. So and there's another concept called that's impossible. I hope I'll try to like explain this. So they give this example of like, there's a room in which you enter. So there are 4 walls to that room. In one wall there's a gate in which you enter, and then there are 3 more walls that 2 are having gates. You try to come out of that gate, you enter another room, and that is having 3 more gates. You try to come out of that door, then you enter another room, and on and on and on. When we talk about the others impossible, it's very much like, you have invention 1. Based on that, you will have invention 2. Very much like, when we talk about the oxygen, I mean, they were able to find the oxygen because they had the scale. I mean, before that, I mean, when they discovered the oxygen, some years before that, they did not have good measuring scale or scale at the macroscopic level, at macro level. Once they had the scale at micro level, they were able to find the oxygen, because the requirement for finding the oxygen was they need to have that scale of that level. Similarly, for YouTube, they need to have the flash player. If they did not, when they did not have flash player, they didn't have YouTube. Once they had the flash player, soon they, came out with the YouTube. So there's something called, you need to have an invention before. Once you have that invention, invention above that is very much like, possible. That is going to happen soon. It may happen within a year, within 2 years, within next decade, and that will happen not by one person, that will happen by many persons, because that invention is very much like possible in near future, because the basic requirements are there in the market, basic technologies are there in the market to make that invention happen. So they say, like, this adjacent possible is phenomenon of almost simultaneous inventions, because once somebody has entered a room, or somebody has made some invention, the invention beyond that, immediately beyond that, that is like adjacent to that, is going to happen soon. And they say, like, there are some condition requirement for simultaneous invention. One of them is, like, you need to have that knowledge and expertise. When you talk about the knowledge and expertise, I would like to, like, give you a bit detail on this. Like, I mean, there are students in the college, or for that matter, like, even the academicians. Some people, like, they haven't invested ample time to learn microprocessor, for example. Now he would know what is there existing in the microprocessor. Now he is the right candidate to make the invention in that field. If somebody is from biology background, he will know nothing about the microprocessor, and therefore he cannot find what is the adjacent possible for that. He will know things into the biology field. And that too, if he is up to date with the invention that is happening. If he is not up to date, then he may be somewhere, maybe like he would be knowing things which happened maybe 30 years before. So what he would be finding the next is what happened maybe 29 years before, 28 years before. In order to make the invention which is going to happen now, he should know what is the technology now that is up to date technology. And then you need to, like, imagine, and then finally they say you need to be lucky as well. So even if, like, you are spending ample time, somebody else may come out with the solution that you are trying to come out with that. They give the example of, like, benzene. The inventor who came out with the structure of the benzene, he was, like, dreaming in the night, and he saw that there's a snake. It is having its tail in its mouth, and suddenly he realized, oh, this is how benzene structure could be. He was just working on this, like, how this benzene is structured, the C and H, how they are connected. Then now we'll talk about the importance of patent document for creating inventions, especially with the academics. When you talk about, so most of the time they spend ample time doing this surveys on that inventions that is happening, but they don't use the patent documents at all. They do mostly, like, research papers. And there's a famous inventor, Levinson. He was famous for, like, doing the invention. What he will do, he will take all the invention in particular field, and he will combine those inventions. He will come out with the new invention based on that in existing invention only. That is how he made inventions, and he had, like, 600 patents in his name when he died. So he, like, he didn't spend much time in the lab at all. So we will try to find out what are the reasons of why one should use patent document as a source of knowledge for creating inventions. Here are some of the statistics. They say 80% of the, this is as per EPO, European Patent Office. 80% of the current technological knowledge can only be found in patent documents. This, if you can understand, that most of the patents are coming from industries, and when they have a new technology, they file a patent, they stop over there. They do not go and file publish a research paper as well. So this technology will never come into the research paper, and that's the 80% of that information never comes into the any other way other than into patents only. So if you are not looking for patents, or if you are not, like, doing the survey of the patent information as well, you are missing 80% of the current technological knowledge. Similarly, they say that 30% of all R&D expenditure is wasted on redeveloping existing inventions. So, and by the way, this I'm talking about from the industry, that even in the industry, they miss to realize that there are technology that is already existing. So they are working on the same technology. Later they realize, oh, it is already there with some of their competitors. That is happening with the industry. when you talk about the academics, since they do not look for the technological knowledge into the patents, they do not know. And I can give you the example of even IIT Madras. Somebody told me that many times they do the PhD in IIT Madras. This is just to give you an example. And they are quite excited that they have come out with some product or some process that is really novel. And when they look, when they try to file the patent for that, they do the search and they come out with the patent that is already there 30 years before, or maybe 40 years before. Somebody has already patented that process or that product. And our reason remains the same because they spend most of the time they spend dealing with the research papers only, not with the patent document information. Similarly, there was another part of the same survey which says like 70% of inventors who took part in the survey they have used that patent information for the invention. 72% they found that patent document information very useful for the innovation work. And there are a few more reasons why you should look for patent information for innovation process. This information, like when you talk about the first to file, I spoke on that in few slides before, that you need to be first to file in order to get the patent. And when you say, since you need to be the first to file, so whenever there is an invention, it would be filed immediately. And you get the latest information in that technology. Another is like, since patent filing is a costly affair, in fact, patent has to be filed, that is a costly affair, then it has to be maintained. You need to pay the maintenance fee as well. That is another cost adds to it. So nobody would be filing a patent which has got no value. So what information you get into patent document is the high value information. You also get to know what the industry is working on. So especially, with the academics, you wish to go into the industry, tomorrow, and in order to, this helps you a lot that what industry is working on. You are not working on some outdated technology and tomorrow you go, this is what I have worked on. This will not help you. If you are looking for the information from patent documents, you have like ample, you have the knowledge like what the industry is working on. And there's a very interesting aspect of the patent document as well. It is for free. So for like IEEE papers, you need to buy if you don't have access, your college is not having access. But patent document is 100% free, and that is globally. So you don't need to buy it at all. And finally, in order to file your own patent, you should know what is existing, and you will have to differentiate your invention from the existing technology. So that for that too, you need to search patent documents. Now, why people don't use this patent document, in fact, for the innovation? The reason is people, they're not aware of the benefits. They don't know where to access it, and they also feel like it's difficult to read, which a little bit of training can help you in that. So I have just listed what are the topics that you have in a patent. In fact, you have got bibliographic data, who is the inventor, who is the company, where it has been filed, and who has in fact filed it, what is the title of the information, what is the abstract of that patent. Then there are drawings, then you have got background of the invention, what existed before, then you have got summary of the invention. This I'm talking about what is there in a patent document, in fact. Then you have got brief description of the drawing, then you have got detailed description of the invention, and then ultimately you have the claims. The claims decides what is your invention. Then these are some of the databases that is free, where you can access the patent document. So you can search. In fact, you not only you can access, you can also search. So you have got Google Patents, you have got ESPASnet, you have got USPTO that is like owned by US. Then you have got WIPO, that is we talked about the PCT convention. So WIPO is from there only. And then this is how you search the patent documents. You have got keyword search, very much like in the Google, you put the keywords, you search for something. You have got inventor search. Once you do the keyword search, you come across some inventor, and this inventor is working on this particular technology. Most of the inventor, like they stick to some technology. Rarely you have inventors who are like working on more than one technology at a time. So once you find some inventor, you can search their inventions. That may help you. Then you also have like assignee search. You also know like some companies working on some mobile communication and they're working on auto industry. So from whichever industry you want to get the patent, you can look for the assignee for that. Assignee is like the owner of the patent. In present scenario, it would be like the company. So maybe the Ford is the assignee, Toyota is the assignee, Tata is the assignee, maybe the LG is the assignee. And then there's something called patent classification. I mean, at least once I tell you, you may have time to like spend some time on the Google. You will get to know what this is. This is called IPC, International Patent Classification, CPC, Cooperative Patent Classification. You have got ICLA by the European Union. You have got USPC, that is by US Patent Classification. So whenever you file a patent, it is classified. It is put into a bucket. So you file a patent in maybe a car. So you talk about like you have come out with some invention which helps, which is about like which is about seat belt. So seat belt is having a separate classification. So all the patents that has been filed for seat belt will go into that classification. So this may also help you with that searching. So if you're looking for the patents in seat belt only, you can go to that particular classification. You look for the classification. You go into that classification. You look for the patents in that, and they all will talk about the seat belts different inventions. So this IPC is like this is being used globally. Now that has been replaced by CPC now, and ICLA is like it is being used in European. I mean in European countries only. Once again, this ICLA has been replaced by CPC. So now even in European countries, it is CPC only. Globally also it is CPC. USPC was being used by US classification. Now this too has been replaced by CPC. Then there's something called citations. You might have heard this step. You might have heard this when we talk about research papers. It is somewhat similar to that. They call it backward citations, forward citations. In any research paper, you cite, you have some references, that would be called backward citations. And then you have got future patents, which will cite your document as their references. That would be called a forward citations. So every patent will have backward citations, that is the references that they have cited while filing the patent document. And then you will have future documents which will cite that particular document. That would be, and all future documents which are citing this particular document, that would be called the forward citations. So if you go by the timeline, so let's talk about the today. Today you file a patent. All the patents that have been cited, that would be filed before your date, and all the forward citations would be filed after 2 days. And they are citing a document. Then you have got patent families. There's some whenever you have got like patent by an inventor, and they are filing the improvements on that invention. So there's invention 1, then there are improvements on that invention. So they will use, there's something called filing date. There's another called priority date. That is like they use the same date, filing date, that this invention is related to that particular invention, and so please use that filing date of that particular patent. In that case, that patent would be called the simple family member of that. That simple family member of the patent that you have filed the first. When you talk about the extended family, in fact, this is a bit complicated. I would prefer like skipping this. This is all about in fact technology. If some inventor is filing the invention in same technology, then that patent would be in this same patent family. And the patent families are 2 different types, simple and extended. That we can maybe another session we can spend some time on that, and then we can talk about this. So now finally you have you have invented something, you have a novel idea. What next? So there's something called conditions of patentability. Then in fact we talked about these conditions, it has to be novel, it has to be non-obvious, it has to be industrially applicable. We talked in the earlier slides. And when you have an invention, how do you decide if it is novel or if it is non-obvious it has got industrial applicability, you do the patent search for that. And how do you do the patent search? You have the keyword search, you have the inventor search we talked about, you have the assignee search, you have the classification search, you have the citation search, you have inventor, you have, I made it inventor search, you have assign. Oh, yeah. So in fact, these five are there. Keyword search, inventor search, assignee search, classification search, and citation search. You use these different ways to search, and you go by the problem solution approach. So you have a problem, you search for the problem, it may have different solutions. And then you also search for the solution that you have given. If somebody else is giving the same solution, if you don't find good patents, then you look for the problem that you are trying to solve. You look for the solution that people have tried to give. And once you have got the prior art, even when I say prior art, I mean you do the search, you came out with some of the patents that is talking about the similar solutions. So that is called like prior art, which is like existing art. And you analyze your invention, the patentability of your invention based on those prior art. If that prior art is talking about exactly what you have invented, then your patent is not novel. It cannot be patented. If it is a bit different, your invention still appears to be like advanced with respect to what existed before, then you can file. This also helps you to know what is your boundary. We talked about the boundary, that there's a real estate, there's a plot A, plot B, and plot C. So plot A is owned by somebody else, plot C is owned by somebody else, plot B you owns. So you should be knowing what owner of the plot A owns, or what is the boundary of plot A, what is the boundary of plot C. Based on that, you will decide your own boundary. If you cross the boundary, if you try to get inside the boundary of plot C or plot A, then you will not be granted the patent. So you should be knowing what is existing, what are the boundary of plot A, what is the boundary of plot C, in order to decide your own boundary. So this, prior art helps you in that as well. And once again, we talked about this is what a patent application contains. So when you are drafting a patent application, you will be having a title, abstract, drawing, background of the invention, summary of the invention, brief description of the drawing, detailed description of the invention, claims. Mostly this has to be done by an expert, not by somebody who has invented. This is not how it works. I mean, it requires a little bit of expertise. I would say, more than that, little bit of expertise. And you better give it to somebody who is an expert. We can also talk about the infringement over here. That when you are filing a patent application, what happens if you are writing a research paper? You just describe your findings into the research paper. This is not the case with the patent. Patent applications filed with the intention that somebody should infringe on this patent application. So it is also filed in a very hideous way as well. Sometimes instead of writing if you have made some invention regarding the mobile, you don't write like mobile. What you say, voice communication device, or you say like communication device or voice communication device or something like that. So somebody is looking for mobile communication, they will not find that patent. Once they miss that, they will come out. They go and manufacture their own products, and then tomorrow you go to them that you are infringing on my patent. So this is how attorney, they call it patent attorney, would write a patent application. When they are writing, they also make it sure that they are not infringing on the rights of, as I give you their plot A and plot C, that they should not get inside plot A or inside plot C. If they go, they will not get the patent as well. So that boundary has to be set, and that has to be done by an expert. So this boundary has to be done in this patent application itself. If you have not done the boundary properly, you will not get the patent. And then in the patent application, you also have got independent claims and dependent claims. When we say independent claims, this is called there are some essential features of an invention that has to be there. So if I give you the example of mobile, then there has to be a mic to speak into. There has to be a speaker to listen from. And you may also have the camera. Camera is not the essential feature of a mobile. Without camera, it's still a mobile. It can still communicate. So that camera will not come into the independent claim. It may come into the dependent claim. And the reason is, once again, when we talk about the independent claim, that is what is infringed upon. when we talk about the infringement, then there should be mapping. There should be like copying all the elements of the independent claim. So if somebody, like if you have a mobile with the camera and you mention that camera here only in the independent claim, and if somebody comes out with the mobile in which he is only having a speaker and a mic, then he is not infringing on your patent. So once again, an expert attorney would know what is the essential feature, what has to be there in the independent claim, what is the independent claim. In fact, an attorney, if you're a inventor, they would ask you, like you say, my invention is having this. So they will ask you straightforward, can you do away with this feature? Can you still, and your invention will still work without this feature? I will say yes, it will. And this is how they decide that what is essential feature, what is not. You being an inventor, you get excited, you have got this feature, you talk about all the features, but they have got to decide what is essential feature, what is not. And whatever extra feature that you are having in your invention, that will come into the dependent claims. So don't worry, that feature will come into the patent, but that will not be part of the independent claim. And the reason is that the main purpose of the patent is somebody should infringe on your invention, and that is, mobile cannot be there without a mic. So if nobody can make a mobile without a mic, if they are making a mobile, they have got to mic. If they are making a mobile, they have got to have a speaker. So if anybody is making a mobile, they will have these two features, and they will be infringing on your patent if you have indeed the first one to make a mobile. And finally, you have got patent prosecution. Once you file a patent, it goes to a patent office, and there's an examiner. They would review your patent application, and they may come back to you with some of the clerical error in your patent application. That is aspect one. Another is they may say they do their own search, and based on that search, they will come back to you and tell you that whatever you have filed, it is already there existing. A part of that is already existing. And once again, your attorney will be in a position to respond back to them. They may amend their claims, they may amend their application, or they may argue back to the examiner that whatever you are saying is not correct. This is how our invention is different from the cited references that you have given. So once again, this is how, once they file a patent has to go through this patent prosecution, and that is taken care by an expert patent attorney. Thank you so much for your time. That's it. Let me know if you are having any questions.
Thank you very much, sir.
You're welcome.
Thank you for this wonderful session. Participants can raise your questions. If you have any queries, you can put it on the chat box so that we can ask the speaker, or you can straight away want to ask the questions to the speakers, you can ask. Yeah. Sindhu ma'am, are you there?
Yes, sir.
Yeah.
The
Sir,
participants
I have a question. So what do you think, for patenting a certain product is more important in your opinion? We have the invention, we don't have a great invention. We just contribute a little to a small, simple novelty is there with a particular product. So how do you think that we can we go for that patent, or what is more required for a product to be patented?
I'm sorry if I missed it again. If you can repeat, please.
Yeah.
If you can repeat your question, please.
So what do you think, for patenting a product?
Yes.
Or any other thing, what is more important? Can we just contribute a little and can we go for the patent, or do we need to have a sufficient novelty or contribution for particular product to go for the patent?
It's a good question. In fact, when we talk about sufficient, it's a bit subjective. What happens? Whatever you have invented, that has to be novel, and there has to be non-obviousness. Now, this is not something a big thing. I'll give you an example. Like I worked on one of the invention. You know this wireless charging, mobile wireless charging. So in the car, what happens? There would be a charger placed. You just need to put the mobile on that, but it has to be in the proper place in order to charge. Now, if you're driving the car, you won't be having much light inside. So how do you decide that? You are having just a line which is glowing actually. if it is if that line is there, then you can put the mobile in between. This is the invention. Now this invention is really big, because if this invention is implemented, it would be implemented in every car. Ford is making a millions of cars, so is the Toyota and other companies. So this will go in millions of cars, and every car, every car manufacturer, for every car, they will have to give $2 to the inventor. So this is a big invention, but this invention appears to be very simple. So it has not to be very complex, and also you don't need to have a product, or you don't need to make a car with that feature in order to file a patent. You just have this idea, you file a patent for this, and then later you can talk to the inventor, talk to the investors. How we can go into the market.
Okay. And
Hello, sir.
thank you, sir.
So I have a question, sir.
Go ahead.
Can I get an IP right just from my result of my research work, sir? Only from my result of my research work. Can I get, sir?
Yes.
I understand. When we talk about the research work, actually what the
Yes,
research work is important. If you have come out with some,
Print निकाल लो.
if you have
Original
come,
कॉपी बंद.
if you have come out with some product which is going to solve some problem, then it can be patented. If you have just discovered something, like for example, like there is some RNA is there, some DNA is there in some animal, that discovery will not be suffice. There has to be a process which is solving some problem, or there has to be a product which is solving some problem. If that is the case, yes, that can be patented.
Oh, thank you, sir.
You're welcome.
There is a question from a participant. If I want to register the intellectual property rights of a scientific project or idea, how can this be done?
Once again, when you talk about the idea, if it is solving some problem, be it a process, be it a product, the process, normally would be, you talk to some patent attorney, they would do the search based on what you have, what the idea is, because you are not an expert in searching the patent document, and you will not be having since you don't have expertise, you will not be able to find the right document, and you may still live under the impression that you have done really something big or something novel, though that novelty is not there. So you need to talk to some patent attorney. They will do the patent search. They will spend, and they will tell you whether that patent invention is novel or not, whatever you have invented. And once it is novel, then patent application has to be drafted with your consultation, and then it will be filed to the government offices. In fact, in India, there are 4 government offices, 4 patent offices. One is in Chennai, and there is in Kolkata, and there is in Mumbai, one is in Delhi. So 4 government offices there. You need to file in either of these government offices, or you can do it online as well.
Thank you, sir. Hope the question is answered.
Okay. Thank you, sir.
You're welcome.
I have another question. We have the patent office in individual countries. Like I have a product I patent in India.
Yes.
If somebody is developing the similar product or similar ideas in some other country, and they patent their own, in their own company, in their own country. So we have 2 different patents for the similar project. Is that be any problem?
No.
Or
that will not be, that normally will not be there.
No, it is like if you patent in India, it is internationally recognized, or it's just within India?
There are two questions to it actually. One is like if you file a patent in India, you don't get any rights outside India. In order to get the right in US, you need to file a patent in US. So if you have filed patent in some particular country, you have your rights protected in that particular country. Yeah,
Okay,
that is answer one. Another is, you said somebody can file a patent in US, you have filed the same patent in India. That will not be the case, because once they file a patent in US, they will do the prior search, and your patent in India will come into their search. They will not be granting their patent to them.
So it means the US patent is international, and Indian patent is only for the national.
No, in India you file a patent that is only for India. In US they file a patent that is only for US. However, when they file a patent in the US, they will not be getting the patent in the US. And the reason is the patent in India is, in fact, after some time, once you file a patent, it gets published. It becomes public. When they do the search for Indian patent applications, publications as well. Once they come across your patent publication, based on that, they will not be granting the patent to somebody in US.
Okay.
That would be called as a prior art. So it is already there in India, so you can't get a patent for this. However, they can
Okay.
manufacture that product in US.
Okay, US will not grant patent to anybody in US since it is already granted in India.
Yes, yes, yes.
Oh, okay. It's only for the case of US or any other country as well.
This is the case everywhere. This is what we talk about PCT. I mean, Paris Convention.
Now, if it is European patent, like
Anywhere.
I have patent in India,
Yes.
can the same work be patented by somebody
No.
in Europe?
Nowhere. Not even in China. Not even in Japan. Nowhere.
Okay.
There may be a
Thank you.
mistake may happen because if they don't
Yeah.
miss to see the patent in India, if they see, they will not.
Okay. Okay, sir. Thank you.
I do have a question over here. There are a lot of researchers over here in our college and our surrounding area. Most often they have a question that they have their work, mostly it's a novel algorithm, and they do have the simulation converted into a program. And some of them have published the papers in reputed journals.
Okay.
Now, what's the next step? Is it possible that they can go for a patent about their novel algorithm? How is the applicability of patenting an algorithm or a software?
Then there are two questions to your. One is like since they have already published a research paper on that, there is a rare I doubt they will be able to file a patent for that because it's already published. It is already publicly disclosed. The one case.
Okay.
Another is filing a software. I mean, software patent in India is a bit difficult. It is being filed, but you need to find a smart attorney to put it the way so that they allow it. Simple software, simple algorithm, they don't allow easily.
Okay, fine. Once we have published in a journal, the same thing could not be patented. That's a clear clarification. And about the algorithm, the software, assume that I do have an algorithm for processing speech signals. If I could embed that in a small hardware and convert that into a patentability product, will it?
Actually, there's a software has to be there with the
Yeah.
some hardware. So yes.
Okay. Software as such is not patentable, but if you combine with some hardware, we can go for patent. Am I right?
This is what they say, that the software is not patentable, but then there are ways and means to patent that.
Okay. Okay, great. Thanks.
Welcome.
Sir, shall I conclude, sir? Yusuf, sir? So I think there is no questions from the participant side.
Yusuf sir, your audio is muted.
Oh, okay. Yeah, sorry. There is another question from participant. Can I register patent just for an idea, not done any research or solved a problem? Is it possible?
Absolutely.
Just for an
even
idea,
when
we can go for.
Yeah.
Even
if you don't have any minimal viable product, can we just file it only based on the idea?
Yeah.
How do we write the claim then?
In fact, this question is a bit difficult. You don't need to have a product. It's simple. You don't need to have a product to file a patent. You just need to have an idea. You don't need to work in a lab. You just thought of some idea, and that it is solving some problem. You just file a patent for this. That idea is suffice. You don't need to have a product. You don't need to work on that actually. Do some.
Okay.
So how many years or days the patent is valid?
It's for 20 years from the
for idea and for product.
No,
is it same or it will be different?
It's the same thing. 20 years for design. That number possibly I doubt the number. I don't remember the number. But design patent. When I say design patent, the way car looks, that is a design patent. But for that, example, I'm not sure, but for idea product, yes, for the development.
Yes.
Okay, we have one more question from the audience. Um, what's the best way to file a patent? Like considering the fact that the public from the filing a patent to publication, it takes like a couple of years. Recently, the government has launched the Startup India, which escalates the process of filing execution of patent. Which do you think for a student? Now, the student does have an idea, and he want to choose which is the best option to file a patent and get the whole process of granting a patent in a timely manner.
Okay, no, I'm not an expert with the Indian patent laws, so
Okay.
I won't be the right person to answer this. But just to give you a general idea, I mean, this is a bit typical that most of the time what happens, there's some student, he has got some idea, and somebody says, yes, you can file a patent. He's spending money from his pocket. I would advise it's not a good idea because there are benefits involved. If it is being funded, well and good. Also, like for in general, expecting something from a patent other than getting recognition that you have a patent granted on your name, that is like add to the resume. If you're expecting some monetary benefit, I mean, like especially getting it licensed or like selling that patent, that is not the norm. In fact, that is, I mean, I would say one out of maybe millions, especially for the students. And from the industry, yes, they make lots of money. For the students in general, not a good idea, like spending money from their own pocket or expecting quite a lot of success.
Okay, great. Thank you.
Yeah.
And
Pavitra is raising an hand. Do you have any question, Pavitra? Pavitra K. Pavitra K has raised a hand, so that I feel like he is having some question. Anybody else? Any participants have any queries? Pavitra K again has raised the hand. What is your question? Pavitra? Okay. If there is
okay,
no
one
more
more.
questions, yeah.
Yeah. Um, uh, for an expert or researcher in a particular field,
Yes.
what do you think is the strategy like to gain monetary benefit from the patent process? Like, is it possible for a researcher who is expert in that in a particular field?
Yes.
Is there a way that he could gain monetary benefit by filing a really good patent and then probably selling it to someone? Is there a strategy for this one?
Once again, I will not be able to give an expert reply, but what I would advise that if you really think that you have really done something great, you better file a patent in India, and then I mean, then you still have 12 months to file in other countries. In that 12 months, you try to find some investor, and if your
Okay.
idea is really great, then investor would like to invest some amount into that. If they do so, fine, go ahead. If they don't do so, there's no point in spending your money from your pocket, because investor would know better what is the value of your patent.
How good or easy do you find this path to travel to for monetary benefit?
How easy it is what?
Hasim,
Yes.
we're gonna cover that in my presentation.
Okay.
Now
Okay.
I think I
Great.
would be
So
happy to take this
very
question.
happy to see you here, sir. Yeah, Mr. Ashok
That's
is
great.
with us. Next speaker. We are very happy to have you here. So we'll be seeing you shortly soon. Yeah. Thank you very much.
Thank you, thank you, Muhammad Ibrahim, for clarification, and thank you, Ashok Shah, for. Okay.
You're welcome.
We'll,
Participants, if you have any queries, we can. Otherwise, we can end up the session now. I think there
Okay.
is no questions from participant. Thank you very much, sir, for your wonderful speech, and hope that participants have enjoyed the session. Thank you once again. Sindhu, ma'am.
Yes, sir.
Yeah.
Okay. So thank you, sir. Thank you, Mohammed Zufra, sir. So thank you for sharing your knowledge with us. So I assure that this session has created an awareness on need and importance of IPR among the faculty and student community, and also it provides better understanding of procedures to be followed for filling patent and to convert research work into patent. So thank you, sir. Thank you once again.
You're welcome.
Um,
Thank you so much for your time.
Thank you, sir.
Bye-bye.
Thank you, bye, sir. So participants, there is a feedback link for session one. I'll post the feedback link in chat box. So kindly submit your feedback, and we'll have a short break up to 11:30. So kindly join at 11:30 for second session.
Have you shared the feedback link, madam?
Yeah, yes, yes.
Okay. Can you share it once again? If not.
So I have shared the feedback link. Kindly submit your feedback for session one. That is for lecture one. So participants, kindly submit your feedback for lecture one. So we'll have a short break. So kindly join at 11:30.
ஹலோ சிந்து மேம், நான் பேசுறது கேக்குதா? இட்ஸ் ஆடிபிள்?
Yes, sir. Yes, sir. It's audible, sir.
ஓகே.
Sindhu ma'am?
Yes, sir.
Yeah, you're there. Okay. Just waiting for the speaker to join.
Okay, okay, sir.
Hello. I think a speaker has joined. Welcome you, sir, Ashok sir.
Hello.
Yeah. Is it okay, sir?
Yeah.
Okay.
Shall we start, sir?
Yeah, you can start, ma'am.
Okay. So welcome back you all for the Impact Lecture Session 2. We'll start our session. I request Mr. A. Muhammad Mian, Associate Professor, Department of ECE, to introduce our speaker. Over to you, sir.
Okay, is it audible?
Yes, sir. It's audible.
Good morning, everybody. Today we have with us eminent personality Mr. Ashok Doplapadi, Manager, Intellectual Property, Mahindra and Mahindra Swaraj Division. Prior Mahindra, he has been associated with Ford Motor Company and Tata Motors IP team with an overall experience of 13 years. He has spoken on multiple seminars organized by European Patent Office, DRDO, Punjab Technology Department, Andhra University. Moving towards his educational qualification, he obtained mechanical engineering from Acharya Nagarjuna University and LLB from Andhra University. He has worked in wide variety of areas, majorly being developing and executing IP filing strategy, developing and managing rewards and recognitions for IP submissions, managing outside counsels for analytical drafting and filing prosecution activities, identification of IPR needs of various levels of R&D meeting and answering questions regarding intellectual property, evaluating competitor in IP landscape to identify their SWOT, university and industry collaboration, counsel in technology transfer process and IP evaluation, contractual management. On behalf of EC Department and Institute Innovation Council, CASAT, we welcome you, sir. Thank you.
Thank you all.
Sir,
Uh,
thank you, sir. Now I request Mr. Ashok Doplapudi, sir, to take over the session. Over to you, sir.
Thank you. Thank you for having me here, and it's a pleasure to be here. So I think Ibrar, who spoke prior me, would have made my job easy because he must have taken you through what are the basics of IP. So can you see my screen? Yeah, can you see my screen?
Yes, sir.
Yes,
Yes, sir.
yes.
Yeah. So I'm going to speak about intellectual property from an organization point of view and from an academic point of view. So since there was a prior session about introduction to intellectual property, I'm not going to spend more time on it. But then my 13 years of experience into IP, I realized that when you realize that you have an intellectual property, be it an idea, be it or an innovation or anything for that reason, when you identify it, there are numerous resources available to you to help you with drafting a patent or filing. So those are ready-made things. But then my understanding of intellectual property working in-house is with majorly Indian firms is the major difficulty that we face in day out is identifying or realizing that to be an invention. That's the first challenge that we face, and then going forward on how to protecting what to file, what not to file. So a disclaimer, the views that I'm trying to express here are personally mine, not my employer. So anything that you create using your brain, I mean, so I'll run quickly through these slides because Ibrahim must have already covered. So anything that you create using your brain has some sort of value. Most of you might have seen the movie Bahubali, right? So if I'm the story writer, if I come to you and say, look, now that movie is made, but imagine for an instance that movie is not made. If I come to you and say, look, I have a storyline, and if I want to sell it to you, how much would you buy it from me? Would you be paying me what I mean, and how much would you pay for a story? Would you pay me 10,000 rupees, 20,000, 1 lakh, 2 lakhs? I mean, and how do you quantify that? Anything that is created using your brain cannot be quantified. So that's the reason where we call it an intangible assets. So there are different kinds of intellectual property, patents, copyrights, and all. So copyrights are given for the expression. From an academic point of view, uh, any I mean, so most of the times wherein professors and lecturers, I mean, so probably things are changing now, but then my understanding or my experience during my college days or anything that you do, the first thing that you tend to do is to publish your paper somewhere on any portal. So if you are publishing any paper, the rights you get are different from the rights that you get when you file a patent. So when you are publishing a paper, that's under copyright. So that's for the expression. So you're the first. If you are the first person to do some research on how to make a car, and you wrote down everything step by step, and if you publish a paper, uh, I mean, so you get copyrights. It's for the expression, wherein it's for your 70 years. It's for your lifetime and 70 years after that. So now, what are the rights? We need to know what are the rights that we get. So if you're publishing a paper, you could stop others from copying that paper or selling that paper or making books or copying that. But if you are filing a patent, the rights you get or you could stop others from using, selling, and manufacturing. Now that you worked on how to make a car and you published a paper, so people studying that paper could manufacture a car, and you have no legal right to stop them if you are publishing it as a paper, unless until you are, publishing, filing it as a patent. So there are different copyright cases that happened in Indian jurisdiction. One such interesting case is on the case that happened in Delhi. Delhi University has a library. So there are many books there from Oxford, Cambridge, and different universities. What generally happens, we as students generally go to library, take the book, get it Xerox, and then use it. So Oxford University and Cambridge University are not happy with that because they realize that students are not buying their books. Instead, they're getting the book from the library and then getting it Xerox from a Xerox shop outside the university. So they had sued both the Delhi government and the uh, small Xerox shop which is in front of them, and the Delhi government for a relief amount. See the amount of relief amount. So all the IP cases that we see day in day out are, when it comes to monetary aspects, they're going to be very big. So the next sort of rights are industrial designs. So see, I come from an automotive company, so my examples are going to be on the automotive line. So when we speak about designs, designs is nothing but protecting your aesthetic appearance of the product when you can't get a patent for it. In comparison to patent, design is slightly weakest, right? But then yes, the reason why we file designs is it protects the aesthetic appearance. So if you have a car and if you're driving in Chennai or Bangalore or any metropolitan city, there are two things on your car which are more susceptible to get damaged. One would be your rear bumper and other would be the side mirror. So let's take the example of the side mirror. Side mirror is very much known, the technology as such. It has a body, sorry, it has a shell, and inside it there is a motor, and then a mirror is cut into that shape so that it is fit into that mirror. So now this technology is very much known for a while, and there is nothing new that you are doing in order to get a patent. Now, since side mirrors are very much replaced, so let's consider this example. If Maruti alone in Bangalore, if it is selling, or in Chennai, if it is selling 10,000 units of side mirrors every month, and each side mirror costs you, just the mirror costs you 300 units. So now how do they protect? 10,000 into 300 is their monthly revenue they are making only by selling the side mirrors. And into 12 is their yearly revenue only for the Chennai, not for the entire Tamil Nadu, only for the Chennai. So when you do this max, you realize that this is a component. You don't have a patent. You don't have anything to stop others from copying. So now how do you protect? So that's where design comes into picture. Design or the aesthetic appearance is done for two reasons. One, for it to be new, and other reason being the aerodynamic aspects of the car. So since the aesthetic appearance is new, so we file design so that it would be protected for 15 years, and we could now people can make any mirror, but not a mirror of my shape, so that they don't fit into my side mirror. This thing. So trademarks is anything that helps you relate to a brand. See, it could be logo, it could be sound. So if you and I are sitting in a room and you logged into Skype, I could tell that you logged into Skype even without looking into your monitor. The sound is very similar. If you show a Kit Kat chocolate without any wrapper on it to a kid, he would be able to identify which chocolate it is. So anything that helps you relate to a brand is trademark protected. So now the the very important and the serious one is patents. So the picture that I have here is Michael Jackson. So now when we speak about inventions, see, uh, when we speak about inventions, when we speak about technical solutions, who are the first people that come to your mind? To me, it would be APJ Abdul Kalam or people of that sort, who would generally tend to be an inspiration or people whom we think of when we speak about innovations and all. But my experience, I realized that it need not be a big people always. People like us, people sitting, even the smallest people could do. So I picked up this example. Michael Jackson, who is he? He is a performer. He's not an science graduate. He's not anything. He is a performer where he had solved or came up with an invention for that shoe, which makes him move that inclination without falling. And he has a patent. So when we speak about patents, when we speak about technical solutions, we should not unplug ourselves. And now, patent, I'm sure Ibrar must have taken you through this. Patent is a grant to your invention. When I say invention, to me, it's a technical solution to anything given by the government, and I would not spend much time on this. So, when we speak about inventions or technical solutions, we generally, that's the general perception where we relate inventions to be rocket science. But my understanding is that it's not. So, most of you might be knowing that seat belts are very much known. Seat belts were there since 1960 or so. So, seat belts are very much known, and airbags are also known. Do you know how an airbag operates in a car? Whenever there is a crash, when I say crash, if there is an impact, there would be a crash sensor in the bumper wherein it senses the amount of force with which you hit another vehicle or an obstacle. So now if that amount of force is more than some delta value, more than some predefined force, then there would be a capsule which blows hot air into the uh, airbag, and then airbag blows up. So now what this inventor said is, this particular invention said, I will create a small passage even to the seat belts so that even the seat belt blows up if there is an impact, reducing the impact of force that the pedestrian or the passenger should go through. So now in this case, the inventor didn't invent seat belt. The inventor didn't invent an airbag. All he did is he created a small passage to the seat belt. Now, creating a passage, would you consider that to be an invention? You Seatbelt is very much known, airbag is very much known, but what you did is you just created a passage to the seatbelt also, so that seatbelt would blow up. So when we speak about inventions, inventions need not be big always. When we speak about inventions, we pull out those inventions, we combine two existing things and such. So the second example is the Coke tin. Prior Coke tin, Coca-Cola was selling Coke in bottles. So this is not. So this is not from an person who has. So this particular Coke tin is developed by an individual inventor. So when you see the Coke tin, uh, he created a small brittle region on the surface. That's how Coke tin is opened, right? they created a small brittle region on top of surface so that it could be easily broken. So now if you're a person who has come up with any invention where you create a small brittle region on top of surface to open it, would you consider it as an invention? I mean, again, you had reduced the metal thickness so that it could be easily broken. So now, if you are that person who has come up with the Coca-Cola tin, would you consider it to be an invention? See the amount of money that he made by creating small brittle region on the top surface, which could be easily broken. Coca-Cola said, "I will give you 1/10 of penny uh, on every tin I sell." So let's assume it to be 10 pies on every tin they sold. Even then, he made about 1,48,000 UK pounds a day. Even if it is Indian INR, Indian rupees, 1,48,000 to be your daily revenue for creating a small brittle region on top of it. It's a good amount of money, and that's, I mean, irrespective of what money you're making, you should, the first thing that comes into any IP is to identify it to be an invention. So when we speak about inventions, the challenge anyone would face is they would think, or people would assume that inventions need to be very much big. No, sometimes these are as small as creating a small brittle region on top of surface, or otherwise creating a new passage or new usage of an existing system. Whatever we see on us, be it zip, be it buttons, everything were once invented. Post it again. Post it was an what you say. It was the engineering team was not intended to come, do that project. They I mean, their objective was to come up with a strong glue, strong adhesive. Someone in the team screwed up, but then they came up with a glue which doesn't leave any marks when it's peeled off. But then 3M identified some potential, and then they filed patent. Now 3M is known for its car care products, but then if 3M has become popular, uh, postage stamp is one such thing that made their brand very popular. Every fridge and almost every home has some sort of post-it on it. Rubber bands, we don't see them as inventions. And the last example, Zillet March 3, is what we see today. It's a classical example of how you could get benefited by filing patents. See, let's take this example of Zillet. Zillet is nothing but three blades inclined at the same angle. So now, since I work for Mahindra, so if I want, I could find a company who would manufacture blades. We could use our CAD engineers and design the same auto shell. But then, why is that there is no other company other than Gillette making three blade technology? Go to Gillette and look into their last year sales. This thing, they are making money. Gillette is making money. But then why is that there is no other competitor being able to enter into that market? Because Zillet has about 35 odd patents on those three blade technology. So now patenting is not just about safeguarding your inventions, protecting your intellectual property. Intellectual property is also about stopping others from entering into market, or otherwise, making your invention more absolute compared to others. So when we speak about inventions, like inventions could be combination of things. Say, fan is very much known, umbrella is very much known, and if I include a fan into an umbrella, your invention is going to be a fan embedded into an umbrella on how you fold it. So if you see the evolution of any product for that reason, be it mobile, be it automotive, be it anything. So whatever we are doing today in 2021 in the area of automotive, in the area of electronics or anything, we are not inventing anything for the first time. What we are trying to do is we are trying to develop over what is already being invented, be it small or big. So anyways, for a patent to be granted, it should be new. When I say it should be new, it should not be there anywhere in the globe. So there are two ways of doing that. One, you should go file a patent. There was a question in the previous session where they were asking, I filed I had published a paper and can I go file? Can I go file a patent for it? No. The reason being, by definition of novelty, it means that it should not be there anywhere in the globe. So, irrespective of who the inventor is, even though it's you, you are the inventor yourself. But then, if you are going and publishing it somewhere, need not be a general where you publish. It could be on in YouTube, it could be on your blog, or or it could be a pamphlet where you had published. So anywhere, if it is publishing, and if the patent office, while examining, uh, is able to find out that document, your own document would act as a prior. The second criteria it should be meeting is it should be having an inventory. So, I mean, so I took the example of an safety pin here. So, so let's understand what's the definition of inventive step. So it says that a feature of an invention that should be either technically advanced compared to existing knowledge or having economical significance or both. Now let's see, what does technical advance mean? So when you invent something, when you are having a technical solution, it should be not there anywhere in the globe. Okay, that's one criteria. The second criteria it should be having is it should have some sort of technical advancement. So now let's compare figure 1 and figure 1 of both the safety pins. Let's try to understand what is it uh, in reality. What does the technical advancement means? Let's compare figure 1 and figure 1. Safety pin to the left is filed in 1849, and safety pin to the right is filed in 1994. And let's compare figure 1 and figure 1. What is that you think the person who got a patent in 1994 to the right had done in terms of technical advancement in order to get a patent in comparison to figure 1? So what he did, from the image I can understand that he had come up with this. He had come up with an where is it? So he had come up with this. So he had come up with this head sort of arrangement so that he could, the other end could be firmly fixed. With this free end could be easily held and the safety pin will not come out. Now creating a small cap sort of arrangement or an closure sort of arrangement, whatever you name it, by creating that simple thing, would you think that it would be a technical advancement? See, when we speak about inventions, the major challenge that any industry, be it the more into it, we face is to identify whether that qualifies to be an invention or not. So, technical advancements, when we speak about technical advancements need not be very big. In this case, creating a small cap sort of arrangement. If it is not technical advancement, from 1849 to 1994, no one had done that. Any invention, when you look at it today, after being invented, hello, any invention, hello,
It's okay. Someone mics was on. Uh,
okay.
yeah.
So any invention, once it is invented, we look at them as things that are already very easy. ये कुछ नहीं किया. This is very simple. But if it is that the case, 1849 से 1994 तक कोई नहीं किया ना. So when we speak about inventions and technical advancement, they could be very simple. They could be as small as this. And lost sort of thing, lost criteria it should be meeting is it should be of some utility being made or used in any sort of industry. So now that since you know what an IPR is and what this thing, so not everything. See, in US, anything under earth is patentable. But in India, no. There are some rules on which what can be patented and what cannot be patented. So it would be very difficult for any person to say what can be patented. So in a smart way, they came up with things where they defined which cannot be patented. Software program per se. When I say software program per se, if you are writing a program on how to print even numbers or odd numbers, the same could be written in C, the same program could be written in C++ or Java. Since it's an expression, they said software program per se is not patentable. So when we speak about software patenting or computer related inventions, generally India would grant patent applications related to computer related applications if it is embedded with a hardware. Otherwise, software program per se is not patentable. You have to go and seek a copyright. That's what generally app developers and others do uh, when they develop their app. Their interface is copyright protected or design protected, and their software program per se is copyright protected. Inventions related to atomic energy are not patented. Method of treating. See, the biomedical devices can be patented, but then the method of doing surgeries, the method of treatment cannot be patented. Business methods per se are not patentable. Agricultural implements are patentable, but then the method of doing agriculture is not patentable. Natural laws, what's already existing, those are discoveries. They cannot be patented. Mathematical formulas per se cannot be patented. If you are from a pharma background or if you are from a chemical background, other form of known substance, say the salts and stuff, they can be different forms of the known substance. So those cannot be patented. So now let's get into how people are doing from an academic point of view. See, I'm trying to get out the statistical data from PCT, how people are filing across the globe. So now, if you see PCT application is nothing but an application filed under Patent Corporate Treaty, wherein you have a chance to enter into different countries. So PCT filing is comparatively costly compared to that of normal filing. But then, yes, let's see. So, University of California was filing about 361 patent applications in the year 2015 and 434 applications in the year 2016. So now, the University of California, I would say, is spending good amount of money, but 361 is their filing or 434 is filing. Is it a good number or bad number? How do you realize whether it's a good number or a big number? So University of California is filing about 75% of what Google files. If you see, Google that same year is filing about 72, 721 in the year 2015 and 584 in the year of 2016. So now an educational institution is filing as almost up to 75% of what Google is filing. Google is an industry where they have their products into multiple domains. So for a company filing versus an university filing, see the difference. But then still, University of California is able to file about 75% of what Google is filing. Why are they doing that? So if you see, University of California for that reason, in terms of they are filing because they had found a way of making money from their IP. See, any IP we file, if it is having some sort of reason, when I say reason, when I invent a product, it's my baby. But then, how would you spend on your baby? You should realize whether it's going to be from an academic from an industry point of view. We don't worry much about licensing because we would want to use those inventions for our products. But then, since you are at a different side of the table, what you generally intend to do is you look into, I mean, so what's the source of making money if you are inventing something? Either you license it or you have a startup for yourself. So, since licensing is going to be the first criteria for an university point of view or from an academia point of view, so that should be the criteria that you should be looking into. So, University of California had made 177 1,77,000 UK US dollars as licensing revenue, 177 millions, right? So that's a good amount of money. So that's the reason where they are filing as equal as Google, or as at least 75% of what Google is doing. They're filing those many number of patent applications because they are generating revenue. Now, if you again, the question here is, will every patent I file, would it make money? I'm not sure. When I say I'm not sure, I mean to say not every horse is going to win. There are some horses which going to win, and there are some horses which is not going to win. So you have to have a systematic approach to what to file, what not to file, so that most of your horses could be making some sort of revenue. So that is from an global perspective. Now let's look at Indian perspective. So even uh, even the Indian universities or in the Indian colleges as such, if you see IITs altogether are filing about 391 top in the list even today. Amity followed almost about century applications. So there are different universities and different colleges that are filing even within India. So again, IITs are filing so much. I mean, then it need not be IITs always, but then they are filing so much. So even the year before that, IITs were top on the list. So now let's ask the question: why are IITs spending so much money on patent filing? Are they making any money, or is it just for the sake of meeting those targets? So why are they doing that? Pehle, if you are a lecturer or a professor, I mean, I think you have to show as part of your this thing that you had published so many papers in a year or so. I think now the UGC had modified it to be patents. But then, are you doing that for the purpose of just having a number into your system, or are you doing that for a purpose? So if you look at how IITs are, making money, IITs in the year 2009 made somewhere about 72 lakhs as their licensing revenue. This is IIT Bombay, which did that. And again, in the year 2013, IIT Madras was able to, generate some 2 crore revenue from their IP licensing. So it's not just the universities or colleges based out in US or any other country doing money, but then it's also about Indian universities and colleges which are able to make some money from the IP. So, what is a systematic approach? I mean, see, if you ask me or if you ask anyone to come up with any idea, there would be hell number of ideas coming up. So now, what's the systematic approach? I mean, so how do you define what to file and what not to file? Because any patent application, if it is, I mean, so once you identify it to be an invention disclosure, for you to get a grant, there would be some cost involved, and like how you pay your house tax every year, you have to pay many renewal fees for the period of 20 years, right? So, how do you decide on what to file and what not to file, where to spend your money? See, any IP for that reason, when you're not able to identify, I mean, then, this is from our from an automotive perspective or from industrial perspective. But if you are a licensing, since academic universities are going to look into licensing approach, so your filing strategy could be entirely different from mine. But then, what I'm trying to give you here is a regular approach. Any IP, unless until you could identify that someone is copying, there's no reason filing a patent. That's the reason wherein KFC had kept its recipe secret as a trade secret, and then Coke and all. So you need to identify inventions which could be identified if someone is copying. So the systematic approach would be to have an better filing strategy, have get broader claims for your patent applications, and then you should build a portfolio. By filing a single patent application, probably it would be very difficult to look from licensing perspective. You should have a portfolio built, you should categorize them, you should rank your patent, and then you should generate hypothesis, identify target, and then approach for an licensing this thing. So what is that? What is a filing strategy? Any patent application, like I said, how easy is it to detect if someone is copying? That could be one of the criteria that you could set off. Or how broader are the claims? See, if the claims are broader and if it is easy to detect, then there is more probability that you can get a more better licensing opportunity, or you could make some money out of your IP rather than rather than filing a patent application, which is very difficult to detect if someone is copying and if it is very narrow claim. So let me speak about what a broader claim is and what a narrow claim is. So let's consider this example. Let's consider you are the person who has invented this pen, what you see on the right, and इसके पहले before this pen, people are using pencils to write or using ink and a feather to write or carving on the stones. So this is the prior art, and pen is your invention. So, like I said, when you have an invention and when you go to when you want to draft your invention to a patent or anything, you have hundreds of resources. Now, the challenge here is who's going to make sense to you or who's going to make some sort of impact to your invention. So, if pen is your invention, I mean, sir, what do you think you would want your patent attorney or any person who's helping you draft that technical document converted into legal format? What do you expect them to draft? So, I mean, so if I am an patent attorney, if I say that I have a ball-pointed pen having a barrel housing, which is the outer housing, and a plunger is this top surface wherein which helps the refill come out and go in, and it has a refill in it, and if it has if I explain everything in detail, so would you be happy with that? Because um, my claim is covering every bits and parts of your whatever you had invented. I had covered every bits and parts of that in my claim. Would you be happy with that? If you are being happy with that, then probably that's not a good approach because see now this is a pen which looks like a jitter pen that we use in every day. So tomorrow, if there is a person who has come up with a Reynolds pen sort of thing or a different sort of pen arrangement, then by going by your claim, he would not be infringing. So when you draft your claims, you should look from a broader perspective to understand how can we stop others from copying our inventions since you are the first person to invent pen. So you got to sit back and think, what is the important thing in my pen? If you come to me for writing in a patent draft for this application, I would ask myself, what is the very important thing? To me, with the very important thing that you had invented in this pen is not the barrel, not the spring, not the refill, but then to me, the important thing that you had invented in this is the nib. So tomorrow, be it Reynolds pen or any other sort of pen, if people change the design and then do anything, they have to come to you for licensing if you file your patent for the nib. So when you come up with an invention, you got to think from a broader perspective to understand what is that very important thing that I should be protecting in this invention. So as an patent attorney, what I would do is I would draft a patent application separately for the nib. I would draft a patent application separately for the ink or the refill that you use, and a separate application for the entire thing. So you are splitting your one single invention into three different patent applications at the same time. You're doing that for a purpose. So tomorrow you would not be able to make money. Say people may not find your entire pen to be reasonably interested to them. They might think that yeah, ease of manufacturing is not easy, or they might think that it's going to be very costly. So now, because you had split your invention into three things, tomorrow he might do some design modifications and make it more easy or easy to use. But then he has to come to you. The reason he has to come to you is you have the patent application filed for the nib. What is the patent application? It has a ball sort of arrangement. When you're writing, the ball is pressed inside, wherein the ink flows slightly outside, so that you crawl on it. So in the same way, when you have inventions coming from an academic point of view, since licensing is your first thing, what you need to do is look into for broader claims. When I say broader claims, see, broader claims and narrow claims are measured by the number of words that you have in the claims. So the first claim has about the first claim which has every element covered has about 137 words. But then the second claim, which is speaking only about the nib, which I thought to be very important aspect of your invention, has only 34 words. So the broader claims or the narrow claims, generally we measure by the number of words that are going into claims. The broader the claim is, the lesser number of words it has, and the more scope of it being able to make some money for you, or it being able to have a better claim. So again, when we write broader claims, you can't be too abstract. You have to have some sort of closureness there also, but then you could go as broad as you can, at the same time avoiding from it being too abstract. So again, the second way of looking at it is, see, imagine you are a person who had invented a fork, and if I'm your patent attorney, and if I wrote it like this: an instrument made up of sterling silver, having a handle attached to the four prongs, since it has four prongs, for piercing or carrying food. So you are an inventor. I wrote exactly what you told me. Then is it being broad by going by the number of words? Yes. It has hardly less than 50 words. So is it broad? No. So you have to keep your eyes open. So tomorrow, if there is any other person who is coming up with two forks or three forks, three pongs or four pongs, or otherwise, see, in this case, they said that this is used for piercing or carrying food. Oh, I would say that I would come up with some sort of arrangement like this, which could be used even for digging sand or digging mud. So I would not restrict it like that. So when you're writing claims, when your attorney writes some claims for you, you should ask yourself, in this case I had used four, is there any possibility that it could be even more or less? So you have to ask questions as such when you're writing, and that makes your claim more broader. So an implement having a handle that comes with two or more prongs. When I say two or more, it could be two prongs or more. When I say more, it could be four, five, six, any number of prongs used for eating or serving food or rising, carrying, piercing, or digging. So when you're filing a patent, you should keep your eyes open. You might be a person who's an expert working in the area of electronics, but then you should be able to identify what are the other areas where I can use my invention. What are the other areas where I could be able to implement? So the first sort of claiming is called central claiming, and then the second sort of claiming, wherein you think from the other aspects, is called peripheral claiming. So peripheral claiming with lesser number of words is going to be uh, the patent application that you should be generally looking into, so that you could make the best out of your invention. Say again, this is a study again, published by United States Patent and Trademark Office. Since I come from a mechanical industry, I had highlighted the mechanical domain. So if you see, people are filing patents with about 70 words as their independent claim, and by the time of grant, there are about 120 words. So this is the number of words wherein which most of the patent applications in the domain of mechanical engineering are filing. Go to any patent application that you filed so far, if you have any, and count the number of words that you have there, and see how many number of words are there. Going forward, you can have it as an equation to see. You can ask your attorney or your patent agent to work on a way so that he could reduce the number of words. And this is also from a legal aspect too. See, if you see, uh, there is a legal case happened, was Centocore versus Abort, wherein the number of words in that claim has about 65 words, which is related to TNF alpha specific antibodies. So now this 65 word claim, when they had disputed in the court of law, they had awarded about 1.7 billion as patent, this thing, 1.7. So there is another fight that happened, wherein rectifier versus access, in the case wherein the claim is about 366 words, and the amount of awards that happened in the case were 6.2 million. So there is almost about 10 power 3 negotiation difference. See, a 65 word claim making about 1.7 billion and a 366 word claim making 6.2 million. So there is almost about 10 power 3 negotiation difference. So be it court or be it your negotiation, the lesser number of words is the broader claim you get, and you have more negotiating power in comparison to having a narrow claim. Going back to the pen as an example, so if you are coming to me and saying, tell me, try to license your this thing for the first claim, which has 137 words, I would not be probably not much interested because, for various reasons, not easy to manufacture that way, or I would find it difficult to find those components. Different reasons, but if your claim has 34 words and if it is only about nib, I might use it in my own design and adaptability. I might be already be having a pen wherein the nib is not accurate enough or not sufficient good enough. So since you had developed a nib which is better than what is already existing, so it's easy to adopt rather than changing my entire product. So when you're drafting broader claims, it helps for you to approach any person for licensing so that it would be easily adopted even at that stage. So now, when you build, when you are filing a patent, you should see. Generally, we file Mahindra search file about 250 odd patents every year. So when we file patents, I mean, sir, it's not, you can't file a single application and expect it to make money always. There could be some inventions which make money, but not every invention. So, you have to file patents which, like in the pen case, the nib, it's first of its kind, which would fall under the center. Then you build a patent chain on it, wherein you file patents about the refill, you file patents about the nib and all, and you build a patent web on it. On see, now in that case, it's a jetter sort of pen, and you could build patent web wherein it says that the pen could be a Reynolds pen or a different sort of pen, wherein you cover the design aspects, and you develop an entire portfolio of that so that it would be easy for you to license. So now, when you have patents of that level, what we generally do here is we categorize them. We categorize apples into apples basket, oranges into oranges basket, so that it be easy for us. So you got to see, even for any organization, you got to basket them into different things so that you know which could be approached to whom, which patent can be approached to whom. So every year, like I said, you got to pay renewal fees. You have to keep checking. Not once you file a patent, it doesn't mean that you have to keep paying your renewal fee for 20 years. Any horse which is not making money, probably you could end up stop paying licensing so that the patent cease to exist. So you can rank all your technology. I mean, in every year you could do this exercise to understand what are the patents that are being filed, what's the quality, what's the market value, and all. You could do a study on that. There are different ways of doing patent ranking. This is one way of doing that. So once you do that, you'd be able to identify which are making sense. So you you have 10 patents. You had categorized them based on which areas they're working on. You had ranked them some patents. Now you want to do a hypothesis generation or a target identification. So let's say you're a person who has invented plastic for the first time, saying that phenol fluoramidine condensation products is what you invented for the first time, which is nothing but plastic for the first time. So you got to identify the hypothesis generation. So when I say hypothesis, you got to identify what are the areas my patent could be adopted. In this case, plastic. Plastic could be adopted into construction. It could be adopted into electronics. It could be adopted into plastic. It could be adopted into transportation. It could be adopted into agricultural vehicles. or agricultural products. It could be adopted into healthcare. It could be adopted into anything. So now that you know that you have a patent and you understand or you realize what are the areas this your particular patent claim can be adopted. So now you do that hypothesis identify, and then from each identified area, you pick up the company or the product to whom you can approach. Say, in this case, plastic is your invention, and you had taken Mahindra from the hypothesis. You realize that automotive is one area where you can approach for licensing. So now you see. If you are taking Mahindra as your potential, this thing, you open their products and see which components in that, which components of the product have that adaptability feature. Say we would say wheel covers can be made up of plastic. If you think that bumpers can be made up of plastic, or the radiator grill, or the fan and filters, or the dashboard, you identify every area where uh, your invention can be adopted into that particular product. After doing that, you have to look how easy is it to adopt. So you have to look to the competitor or the any company where you want to license. You have to see which product of them you can adopt to, and in the product you have to look into which components those your invention can be adopted. Once it is identified, you have to see whether they have any similar IP, or are there any alternatives IP, and how easy is your solution to adopt, and is it cost effective or not. So once you do this analysis, so if you think that your invention can be adopted to wheel cover, and you realize that Mahindra has no IP in that area, and if you think that there are alternatives to that which are already pending, and if it is cost effective, business advantage 9, probably they would not look at you. But then if you see that adaptability is there, they don't have any similar IP, and they don't have any alternative solutions with them pending, what they are doing is they're buying it from somewhere, and if it is cost effective and if it is having business advantage, then you could approach them and say, look, I have a technology which could be very relevant to you, wherein you, as on date, you're spending so much or you are importing so many number of components from them. But then what I could do is I have a technology which I could license to you so that your entire production cost can go down by paying me some sort of licensing revenue on everything you sell. So this is one way of identifying target assessment. And if you think that they're already using your invention, then you have to identify the evidence of use. You have to identify the evidence of use. So when I say evidence of use, let's see this claim. If my patent has a claim like this, a fuzzy structure that fetches a ball comprising a tail, at least one wet nose, and a plurality of legs. If this is your claim, so now what you need to do is you need to look into the competitor product to see whether he is adopting or he has the same thing. So the product as such, say Ashok has a kennel wherein which sells dogs and puppies, which fetches ball. So in that case, it is matching. So whether my product has a tail, yes, my product has a tail. Whether it has a wet nose, yes, it has a wet nose which looks like that. And does it have plurality of legs? In this case, it has 4 legs. So in this case, what you're trying to do is you have a patent, and if you think that there is some company or product which is already using technology related to your patent, you can't just go to them and say, look, you're infringing on my patent. What you need to do is you need to make an evidence of use first. You got to compare their product with your patent claim and see which part of your claim they are copying, and then make a chat like this, and then this would be the better start wherein you could sit for a licensing agreement. So by making these basic details of the invention disclosures of what you had invented at your university or anything, and that's where you propose a license, and that would be easy to start. So now we spoke about IP, we spoke about the money the University of California is making, or any company is making. So now, does every IP that we file makes money? No. See, if you see, this is again University of Stanford, they have about 2,290 patents filed in US, and they make about 49.3 millions of licensing revenue. So 2,290 patent applications making 49.33 million licensing revenue. Would it be the apt approach to look at it? No, it would not be the correct way of looking at it, because if you see, more than 100K of licensing revenue is from 49 patent applications, and more than 1 million in royalties is from 5 patent applications. So it's not 2,290 patent applications that they have are making this money of 49.3 millions, but then it's about 875 technologies that is generating revenue. So sometimes when we file patents, you may not be able to see uh, IP revenue in the very first go, or in the very first year you file. Sometimes your IP could be a support system to the IP that is already there, and that could help you generate revenue. So with that, I come to an end. See, any invention for that reason. Any invention, once it is invented, it's very much known to public, but then before inventing, I mentioned before the product comes into picture, you can't quantify it to some value and say, My invention is this." If you look at automotive again, autonomous cars, people have been filing patents for autonomous cars since 1995-96. But then autonomous cars are not in India still. Google is trying, Tesla is trying, to make a very workable autonomous car. But then, since 96 to 2021 is quite a time, right? Almost 25 years now. But then still there is no governing law even in India. So when we invent something, we got to be looking how much is it market adaptability, when is it gonna come, and all. Other example is, my dad used to say this to me uh, when he was getting married. When people of my parents' age were married, there was one thing that is most sought as dowry. Those days, Bajaj Chetak. If a girl, if a father of a girl want to uh, get his daughter married, the first thing he would do before even searching for a girl is to go to a Bajaj showroom and order for a Chetak, because people those days used to ask Bajaj Chetak as dowry. So people used to wait for 6 months to 3 months to 6 months as waiting time in order to get your Bajaj Chetak once you pay money. So that was the amount of wait time that people used to wait. And at the same time, Bajaj was holding about 95% market share that time. There was no other two-wheeler company that time. There are small chota mota companies, but then Bajaj was the major market share company, selling more number of products. See, Bajaj at one point in time, government said, "Look, you need to put indicators on both sides to indicate which way you are turning as a safety majority." But then Bajaj said, "Look, we would not be adopting that to the government. Since Bajaj is the market leader, they are able to say that." But then what happened? Um, Hero came into India. Honda came into India, clubbed with Hero Motors, and then they made Bajaj Splendor. Sorry, Hero Honda Splendor. And once Hero Honda Splendor came into picture from 96 or 95, Bajaj lost its market share drastically. Until then, they were the market leaders. They were they were on rock. They were the market leaders. I mean, they never cared for anyone. One fine day, Honda came into India, clubbed with Hero, launched a product which is very innovative, and then Bajaj is nowhere seen until they launch Pulsar again. So you can't sit on your pile of inventions which are already done, or you can't sit on your products which are making money and ride on it too long. Uh, at least until recent times, when you speak about automotive companies, if you ask Ashok, who are your competitors, I mention it would have been easy for me to say Tata Motors, Ford, Daimler, Volkswagen. These to be my competitors from an automotive perspective. But then if you see the changing trend today, Google is into autonomous vehicles. There are many companies which you even don't know which are working on autonomous this thing. Before this, when you speak about automotive company is purely a mechanical company. Now, automotive company is a mechatronics company. So, wherein there are many electronic components involved. It's all about programming, how you program. So, with the changing in this thing now, even from an industry point of view, you never knew who the competitor is, and it's where the educational institutions can, make so much leverage on. So, in order to invent, you don't have to have a company, but then you can work on, you could realize what are the technologies. You can make an analysis on what are the technologies that industries are adopting, or what are the areas where industry is moving into. So, as such, in an automotive, you could see people are moving from diesel vehicles to fossil fuel vehicles or electric vehicles. If you're in college, if you develop this to be a strategy where you would work on developing electrical vehicle technologies, and if you develop them and if you can go to any company and approach them for a license, that's where they would be interested rather than inventing which is not relevant. So if you can focus your even the R&D strategy, or where you want to work on in the areas where people are trying to invent, or where the people are migrating, even from an electrical point of view. If you see, 3G technology was previously used. Now people are speaking about 5G technology. Why Qualcomm or any US company is very much worried about 5G technology is, 5G is mostly developed by Chinese companies, and they have about 100. They have more than 10,000 patents in the area of 5G technology. So now, since mobile is all about safety and security, they are concerned. So inventions, you got to look where the market is switching into, and if as an university and as a college, if you can focus in those areas and work on the future technologies that are going to come, then it would be easy for you to pitch into for some sort of licensing revenue and things like that. But yeah, that's it. I think I'm open for questions now.
Yeah. Thank you very much, sir, for your wonderful speech. I hope the participants have gained the enough knowledge on the patent and how they can how they can implement their project or their product into a patent. So they got like sufficient idea about it. So you have discretized everything, how a project or a product can be applied for a patent, what are the points to be considered, and everything you have elaborated very perfectly. Uh, I hope so participants have enjoyed the session. And now it's the time for the participant to ask the queries. Participants who have any queries, you can put it on the chat box so we can ask them. There is a question from a participant. What is the best way for an inventor to find out where and how his invention is classified under the IPC, International Patent Classification?
See, WIPO, if you go into WIPO portal, there are different ways, even European patent classification. See, there are IPC is one classification, International Patent Classification, EPC, European Patent Classification, US Patent Classification, and there is one more called F term for Japanese Patent Classification. So, I would suggest going by classification search alone would pull you hundreds of patents if you're trying to find out. If you're trying to find out prior art, what's been existing, going by classification search alone would be not the proper way. You should include it with your search strings and all. But then WIPO, IPC, you can find it on the WIPO portal. F term, you can find it on the Japanese Patent Office. ECLA, European Patent Classification, you can find it on the European Patent Office website. US classification, you can find it on the US Patent Office.
I hope the question is clear. And there is another question. What is the difference between intellectual property and intellectual capital?
When we coin the word capital, it's about property. See, okay, intellectual property is something that you create using your brain. Let's get into the basic example. You have money, you have two houses. One house you use it to yourself, another house you may rent it or you keep it idle. End of the day, it's your property. In the same way, inventions or expressions, where anything that is created from your expression is a copyright. It could be drama or anything or a drawing. If it is a technical solution, it is patented. Those are intellectual property. Intellectual capital is again the money that you are able to generate using your intellectual property.
Yeah. There is another question. Who owns the IPR in published article because it has first author and co-author?
Sir, I don't think that even both the first author, second author doesn't hold any ownership in that article. I mean, when we are submitting in any article to any this thing, I'm not sure how many times you read the terms and conditions, but then if you have read the terms and conditions, many of the sites says that the ownership lies with them. See, the best example is if you are the owner, if you are having any sort of ownership, if it is a paid website, for every download anyone does for your paper, if they are charging $10 or $5 for every download, how much money are you getting? You would not be getting any money because you hold no ownership. Generally, the portals which owns it, be it Science Direct or anything, when you're uploading, they say that if you read the terms and conditions very properly, they say that you're transferring all your rights to them. That's where they're making money out of your writings. So that is where some of the universities and some of the colleges have started their own journal where they publish papers coming from their university or college. That's one way of doing it, but since you don't get international attraction to it, that's where people approach Science Direct or any other publication. But then when you approach and file in those publications, in all cases, I believe you're transferring all your rights.
Yeah. Usually, when we submit a paper in or article in some journals or conference, so like they made it like a copyright. So usually the papers, the articles in the journals are copyright. On the other hand, we have a patent, as like you have mentioned earlier. So copyright and patents are two different cases. But what we came to know is like once we have published a paper in a journal, we can't patent it. So
Yes, you
once it
can
is
patent it, and even before publishing, if you want, before you click on the submit button, there would be terms and conditions. If you
Yeah.
click on that and read it, I'm
Uh-huh.
sure there would be a clause in it saying that you're transferring your IP rights to the publisher.
Yeah. So
So that's where
it
you're
is a
losing
case
the
if you are
ownership.
going for the patent. Yeah. Yes, yes.
If you're going for a patent, you file it in the name. See, again, there is always a confusion when it comes from academic point of view on who
Yeah.
owns the IP. Since you're using the university resources or the college resources to develop, generally the university, or if it is an lecturer or a professor by virtue of your employment agreement, all the IP generated should belong to the company. It all depends on what sort of contract you have with your company, with your college or the university, whether the university
University, yes.
allows you to own, or whether the college allows you to own, because at the end of the day, you got to pay renewal fees and everything. So
Yeah.
if the college has to bear, then they have to have a strategy on what to file, what not to file.
Yeah. I don't know. My question is like, what's the difference between the copyright and the patent? So we go for the journal and we go for the patent.
Mhm.
So we go for the journal, it is merely a copyright. Ideas and our work has been just like copyright. We publish them as a article, but it's just published. So how does it differs with the patent? If we patent the same thing, so how does it get differs?
Sir, patent has okay. Copyright is given for your expression. So now, so you're publishing a paper on how to make a car. Okay, you
Yeah.
had done 6 months of study on different things, and you had for the first time came out with that idea of car, and then you're publishing a paper on how to make a car. So when you publish it with any general, the rights that you get are copyrights. So when you copyright, the rights that you or the publisher gets is you could stop others from using that expression. Copyrights are given for the expression, so they can't reproduce. If or otherwise, you say, I say that you had published a book on how to make a car. Now people reading that can make a car, since it's a copyrighted thing. They can study that material and build a car, but they can't copy that book and reprint that book and sell.
Okay.
But if you
Okay. Okay.
file a
Understand.
patent, you have a claim in it, so you could stop others from using, selling, and manufacturing that technical invention.
Exactly. Exactly. Understand. Understand. The concept is clear. Any other questions, please?
Yeah, Mr. Ashok, you wanted to take my question in your session.
Yeah.
I will rephrase my question like for a researcher over here who is expert in any particular domain,
Mhm.
how do you think that he can take the path of monetization through the patent? Okay,
See, if you have to monetize, like you said, you got to do some analysis. Firstly, understand which company or which product your patent is related to, and you need to see, say, your patent is related to automotive, which is related to engines.
okay,
So your possible licensing opportunities are with Indian companies or any company: Tata Motors, Bosch, Mahindra, Ford, Daimler, पांच छह automotive companies है.
yeah,
If you go beyond that, there are lot Ashok Leyland and stuff. Now you go to their IP portfolio and see if they have any relevant thing or not. अगर मेरे पास, if I have a patent, why would I come and take a license from you?
okay,
If I don't have any patent, then I would take. Or even if I have a patent, but then if your patent is easy to adopt into my existing product line, and if it is having some business impact or economical significance, some sort of money, if it is helping me reduce weight, or if it is helping me have business advantage, if it is giving more mileage, so you should buy me with those studies. By merely approaching me saying that I have a patent, would you want to licensing? I would not even read that email.
okay,
If you make a systematic approach on saying, Ajay, you have a product, I have a patent, but then your product has this technology. My patent will help you reduce weight or help you increase fuel efficiency or help you reduce the number of components involved. And my patent technology is plug-in. You don't have to do any changes. You just need to modify slightly so that it would be easier, plug and play sort of thing. If you're coming to me with some sort of systematical approach as such, then it would be easy for me. I would look into that emails for a consideration.
okay, great. So is this the approach the IITs follow?
Yeah, I mean, when they make a portfolio, they make a hypothesis about whom to approach.
Okay, so it is going to be a top-down approach. You first analyze the target and then look down what are the fields in which the invention could be patentable, and then they
Yeah,
try to invent something around that area.
yeah, yeah.
So it's never going to be a bottom-up approach. How will the bottom-up approach work? Like I
See,
have done something
bottom
something
up.
novel.
Bottom up approach would work if your product is entirely new. Say,
Okay,
abhi 5G technology is known. If you are a person who is working on 6G or 7G technology,
okay, that will
since
be
no
new.
product is there,
Okay.
Then see, recently Tesla said they will license all their IP if someone wanted. The reason
Yeah.
why they said that is the reason why they said that is so that their technology would be the center technology, like DC versus AC, where the entire electrical system was developed around that.
Mhm.
So in the same way, Tesla said that we will license in the autonomous technology. So now people will build technologies on top of that. So their technology would be the base of crux of what's very important. So now, in the same way, in the bottom-up approach, if you're a person who is inventing something on the 6G technology, which is yet to be, researched or yet to be ventured into, then probably bottom-up approach works. But if you're working on something very much known, engines is very much known, and bottom-up approach would not be much useful. Top-down approach would be very much useful.
Okay, great. I'm good that you took up the Tesla's view. That was my lined up question. Like Tesla has open sourced their patents and willing to license it to for free. And how do you think, from a business perspective, do we able to gain through it?
Okay, I mean, it's like now Tesla has some basic technology on the autonomous vehicles and electric vehicle. This thing. So now any technology that is developed on top of it would be uh, an adoption to it. Say you have a phone, and tomorrow someone says, "I will include a camera to it." Say
Mhm.
basic phone I'm speaking. So you're saying that my phone license could be easily you could use it. So now you're a company who thinks that I will include a camera to it. Phone
Okay.
software is that's what Android did. Android gave it for free, wherein people developed many things. Wherein now Android phones are more sold compared to that of Apple. Android is more used. In the same way, Tesla is doing that. So when it comes to business adaptability, they want to make their technology to be the center, very ingredient crux of it, so that all the technologies would be developed around that.
Okay, so the technology becomes the base of next
Yeah,
newly developed technology. Okay, so
yeah,
as of now, they won't be getting any revenue out of it, but it will become the base technology in the future. That's what they wish for.
yeah.
Okay, great.
There was a question: can patent be sold? Yes, it's a property. It could be sold. It could be licensed. No, I don't think people can mortgage in India, but in US and other countries, you could even mortgage your IP. You could go and get some loan on your IP.
Okay. Thank you, Mr. Ashok. Thanks for the wonderful session. Do you have the participant doesn't do you have any other queries? So we can you can place your queries. Otherwise, we can end up the session now. Sindhu, ma'am.
Yes, sir.
Yeah. I
Okay.
think like the question is over. So
Okay, sir.
we can
Okay, thank you, Ashok sir. Thank you for sharing your knowledge with us. I ensure that this session has created an awareness on how IPSL can support all innovation, creativity, and IPR related endeavors of students, researchers, faculty members, and all innovators. Thank you, sir. Thank you once again for joining. So now I invite Mr. C. Muhammad Hashim, Assistant Professor, Triple Department, to propose a vote of thanks. Over to you, sir.
I wish to thank our correspondent, Dr. Abdul Latif Saheb, and our chairman, Dr. Yez Ziauddin Ahmad Saheb, our principal, and our IIC president, Dr. C. Mohammad Yusuf, our IIC team members and ambassadors, and all my colleagues for their continuous support and encouragement in this event. Special thanks to Minister of Education's IIC for this wonderful initiative. And most importantly, I extend my sincere thanks to our eminent, knowledgeable, experienced speaker, Mr. Muhammad Ibrar and Mr. Ashok, for accepting our invitation in the busiest schedule to grace the event. Thank you, Mr. Ashok. Definitely ensure this session has created an awareness on IPR among the student and faculty. And I convey my sincere thanks to all the participants who made this event very interactive and knowledgeable one. Once again, thank you all. Over to
Thank
Sindhu.
Thank you, sir. So, dear participants, the feedback link for session 2 and e-assessment link is posted in chat box. So kindly submit the assessment form and the session feedback.
So you will be getting the certificate upon the completion of the feedback. So kindly complete the feedback to get your certificate and the assessment as well. Thank you very much. Thank you all.
Thank Dear participants, kindly submit the feedback form and assessment link. Participants are requested to submit the feedback link for lecture 2 and e-assessment. The link is posted in chat box. So I request you all to submit the both feedback as well as assessment. So regarding certificate, you will receive a certificate within a week through your mail.
क्या बोले? हाँ.
So participants also submitted, you can leave the session. So thank you for joining.
Send me the link one more time, ma'am.
So participants, if you have submitted the feedback and assessment, you may leave the session. Thank you.